argument would be this, that if the whole argument, and that has been our case since we first came here last Tuesday, that we cannot, my Lord, be able to have a situations in which the petitioners are saying the constitutions of Kenya has been systematically violated, and that all these obsessions with the application to set aside the conservatory orders that are in place are meant to complete the violations of the constitutions. My Lord, under the constitutions, your first duty is to defend the constitution. That duty is particularly greater for the simple reason, is it called Meduse? The MP, Metuse, that one. When the mover of the motion had that duty under the constitutions, President of Kenya had that duty when conducting, making appointment under 149, National Assembly had that duty, and the Senate. But my Lord, you are saying in those 5 instances, the constitution has been violated. And because, my Lord, the constitution has been violated by individual state officers who are under a duty to uphold the constitution, then the duty of this court to ensure that we do not turn this constitution into a mere platitudes, into a hollow documents, a false prospectus, is all the more greater. And it is for those reasons, my Lord, that I would be saying that everything would become nugatory when they can be able to say, mission accomplished. They can go one day after the ruling. They can go to Uhuru Park or whichever other place for them to say, we are swearing Kindiki. That would be a mockery of justice. But there is a greater mockery of justice that I would want to point out. Because this thing, and to break it down for the people, every order in the normal litigations we do with every day, and you say somebody's rights are going to be violated. If somebody is saying I should not be hanged, I was not convicted properly by the High Court, if, my Lord, that person is hanged before he has been heard by the Court of Appeal, clearly it would mean that the process of justice had not been completed, yet we have hanged the guy. My Lord, in America, they keep on hanging people. Many of them terrible criminals, mass killers. But, my Lord, you will observe that at the time when we see these televised killings in America, it is always after they have exhausted judicial process, so that they are sure that process that are irreversible take place after every legal benefit and protection has been accorded. One of those that is important, my Lord, is captured under Article 27 of the Constitutions, the right to protection of law. So that the issue, as long as I'm in court, the matter is not yet over. It might well be possible that we might lose this application, the interim application that is before the court. But we might also win it, and we are likely to win it. So that because, my Lord, of that issue, that a person may actually succeed at the other stage is the reason why you prevent taking irreversible decisions. And, my Lord, what is the scenario that we are talking here? My Lord, with the scenario here we are talking about here is simple. Immediately after assuming the orders were lifted, that's the scenario I want to describe. What is it that is going to happen? My Lord, we would have a scenario where the Chief Justice, whilst these proceedings are pending before the court, would have to preside over the swearing in of Honorable Kindiki.
My Lord, is it in order for my Lord friend to keep speculating about the swearing in of Professor Kindiki?
Lord, the issue of swearing in
is also, and he's referred to it 3 times now. This is the 4th time.
My Lord, I believe that's the law. They have been saying they want to.
And my Lord, whereas you allow
then.
I was to ask my Lord, what is the dispute before you? Is it the impeachment and whether it was lawful? Or is it the nomination of the second interested party? Because
first of all, it's both, and I would want some protection for me to conclude so that we are all fair. They will have their time to respond, and I will not interfere with it. My Lord, so that the important scenario that we must seek to avoid is a situation, and this is matter, it is also a matter both of the Constitution and statute law. My Lord, the issue is that if we get ourselves into a situation in which the Honorable, the Chief Justice, might have to preside over the swearing in of Honorable Kindiki while this petition is pending, my Lord, that, to borrow the words of Honorable, my friend Mungai, Senior Counsel, would be the greatest absurdity that we can encounter. Why is it an absurdity? It's an absurdity, my Lord, for the simple reason that one of the authorities that we have cited is the Assumption of Office Act, where, because of the experiences that this republic went through in the years 2007, 2008, specific laws had to be made to ensure that not only will this event be a public event. That's number one. But the more important issue from the standpoint of law is this, that before we get there, all legal disputes, contestations over the right to occupy that office would have been resolved. And my Lord, that is the reason precisely why they say, after the Supreme Court has confirmed the validity of those two positions, then you do the swearing. My Lord, it would amount to taking us back if that aspect, that rule of civilizations, were to be taken away on account of the setting aside of the conservatory orders that were issued, and for very good reasons, by your brother judges. I don't know whether there was a sister, by your brother judges. So that, my Lord, the issue, as far as we are concerned, that is an absolutely important issue. We go to the next important issue, public interest. My Lord, public interest has been defined in very many cases that are before you. And my Lord, these public interest issues are just supposed to ensure that in administering justice, the court will do the right thing. Because we actually have a transformative, one of the best constitutions in the world, for the simple reason that we wanted to be a good example across the world as a leading constitutional democracy. And as a leading constitutional democracy, the issues of public interest is placed at the heart of our constitutional order. I go, my Lord, to the definition. This is the only long passage that I will be reading. And this is, I gave the supplementary authorities earlier. This is in the famous case of Murungaro, Christopher Daradhi Murungaro versus Kenya Anti-Corruption. This I'm citing the passage appearing at page 7 to 8. My learned senior, Mungai, will be familiar with this decision. My Lord, from the last paragraph, what did the Court of Appeal say on public interest? I read, it said as follows. Lastly, before we leave the matter, Professor Mungai told us that their strongest point on the motion before us is the public interest. We understood him to be saying that the Kenyan public is very impatient with the fact that cases involving corruption or economic crimes hardly go on in the courts because of applications like the one we are dealing with. Our short answer to Professor Mungai is this. We recognize and are all aware of the fact that the public has a legitimate interest in seeing that a crime of whatever nature is detected, prosecuted, and adequately punished. But in our view, the Constitution of the Republic is a reflection of the supreme public interest, and its provision must be upheld by the courts, sometimes even to the annoyance of the public. The only institution charged with the duty to interpret the Constitution of the Republic and to enforce those provisions is the High Court, and where it is permissible, with an appeal to the Court of Appeal. We have said before and we repeat it. The Kenyan nation has chosen the path of democracy. Our Constitution itself talks of what is justifiable in a democratic society. Democracy is often an inefficient and at times a messy system. A dictatorship, on the other hand, might be quite efficient and less messy. In a dictatorship, We could simply round up all those persons we suspect to be involved in corruptions and economic crimes and simply lock them up without much ado. That is not the path Kenya has taken. It has opted for the rule of law, and the rule of law implies due process. The courts must stick to that path, even if the public may, in any particular case, want a contrary thing, and even if those who are mighty and powerful might ignore the court's decisions. Occasionally, those who have been mighty and powerful are the ones who have run to seek the protections of the courts when the circumstances have changed. The courts must continue to give justice to all and sundry, irrespective of their status or former status. What orders should we make in the motion before us? So then, my Lord, I make 3 points with regard to what is public interest as understood by the Court of Appeal. Number 1 is that public interest means enforcement of the constitutions of Kenya. Secondly, my Lord, to make the point from what we have cited, that the first duty of ensuring that you both protect the Constitution of Kenya and you protect public interest is vested in the High Court. Every other court above the High Court, the Court of Appeal, the Supreme Court, they can only do that on the basis that they are sitting in an appeal on a decision already made by the High Court. So that, my Lord, it will be the submission that this reinforces the huge burden that this court must undertake. And, my Lord, the final issue that was being understood here is to say a constitutional democracy would not mean anything unless due process is upheld. And due process is the first duty of the High Court to ensure that in whatever dispute that is before the court, before it is decided, the court has confirmed due process has been observed, and as a constitutional democracy, that is a standard, because they try to compare ourselves with a dictatorship, that as a constitutional democracy, we can live with a decision. As my learned colleague, Mr. Ngoya, was saying, we cannot possibly live with a decision in which we would be seeing the Chief Justice, where, if that were to be the case, you would be seeing the Chief Justice swearing Honorable Kindiki while we are arguing this matter before the court. So that the rules are clear, the rules do not require much elaboration on what they mean. And since that criterion of public interest has been made by the Supreme Court itself, my Lord, I urge you to uphold it in the manner that will best ensure that the constitutions of Kenya and its dignity have been upheld. My Lord, there is the question, so that I believe that we are very clear on public interest, except to emphasize that for the specifics of this case, what does the call of public interest require this court to do? It's a simple call, 5 quick things. Number 1, to confirm that the law on impeachment has been properly interpreted and applied. That's the first issue. To confirm that the laws on impeachment has been properly interpreted and applied. Number 2 is to achieve substantive justice for the parties, so that when a judgment will be issued by this court, at least everybody can win something, that nobody goes home with a whole of victory. That is the whole idea of substantive justice. The third issue is to determine that the issues of the violations of the constitutions is done while the matter is still alive before the court. My Lord, very serious issues on Articles 27, 38, and 50 of the constitutions have been raised. They are all under the Bill of Rights. We urge that while public interest needs to be upheld by ensuring that when this court pronounces itself in a judgment, those issues would not have been turned into academic. Number 4, my Lord, is to ensure that the integrity of the presidential or political succession that is written in express law under our constitution is not rendered ridiculous or ineffective. And in those, I point out what we had said earlier. The desire of the makers of the constitution was any person who will hold the office of deputy president and therefore can potentially become president without an elections ought himself to be an elected official. So that it's a big thing if this office, and without good reason, except political malice, is held by an appointed person. It is in public interest that an elected deputy president, except for the clearest of evidence, except for the greatest of sins that are clear to all men of justice, is not removed from office. My Lord, the fifth issue is to do this, that this court protects the constitutions. I've already talked something about it, so I don't have to go much into it. My Lord, there are only two decisions before I sit down that I would like to point myself to. There is the issues of Githunguri versus Attorney General. It is one of the cases that are before you. The facts in Githunguri are notorious, and they are also notorious for the simple reason that that decision, those old advocates who are there, Kina Paul Muite and Dr. Gibson Kamau Kuria tells us, that it was largely, though it was a 3-judge bench, it was written in the style of Chief Justice Madan. My Lord, that issue said something that is important to me, the younger advocates in Kenya. And what it said is this: it emphasized the question of justice. And it emphasized the question of justice. There is the simplest meaning in plain English. You need to ensure everybody has a fair and square deal. This is to say that at the end of the day, everybody will leave the court and says, probably my advocate was not as good as I thought, but the judge did their best. But at the end of the day, let it be very clear that the court did everything that is possible to ensure that justice in its substantive form is achieved. This decision was rendered in 1984, long before the article on 159 was written, and that is why it is celebrated. And my Lord, it is also celebrated, and I am mentioning here for that reason, whenever honorable men, candidates before the Judicial Service Commissions are called upon to name whose jurisprudence has affected them, it is Justice Madan that is mentioned very many times. I will strive to be like Justice Madan. And my Lord, it is for good reason. All of us celebrate Justice Madan because he strived to do justice. But my Lord, in the same case, the older lawyers also told us about Alan Hancock's, about Dugdale, and even about Chunga. They tell us all these stories. But my Lord, in those interviews, I do not hear anybody saying I want to be like Alan Hancock's. So that, my Lord, I cite Madan in order to support the proposition that Judge Madan would never remove the conservatory orders that are before you, under the principles of doing justice and offering everybody a fair and square deal. The last case that I would want to cite, before I hand over to my learned colleague, Professor Ogada, has he gone? Oh, I thought whether he has disappeared. But Lord, before I hand over to my learned colleague, is to point out to one little issue.
The petitioners, you have exhausted 2.5 hours. Budget how you are going to...
Yes, sir. Yes, my Lord, we are budgeting.
With the remaining,
yes,
no more than 30 minutes.
Yes,
anybody
my Lord,
who wants
understanding,
submit on your side,
yes,
we'll
try to do our best.
Have no more than 30 minutes.
Thank you. We'll do our best. My Lord, for purposes of this case, this is the only thing I'm citing before I go. This decision, like you've had very many other decisions on constituent power and everything, this will be an international decision. It's a decision that will be read by universities across the country. And therefore, the least that I can do is to confirm that the lawyers for the petition are still familiarized themselves, as Macharia tried to do, with what other courts internationally have said. There is just like a small issue that I want to address myself to. My Lord, in 1928, in the case of Olmsted versus United States, one of the most celebrated justices of the U.S. Supreme Court, Justice Brandeis, says as follows. This is important. Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. End of quote. I quote the words of Justice Brandeis in order to make the point that in the matters, the proceedings before this court, we have been treated to a scenario under which an impeachment process that, if you read the constitutions clearly, is a process that ought to be a legislative one, a process conducted by the legislative organs of the Kenyan state, has been converted into an all organs of government project. With the result, my lord, that if the petitioners turns out to be right, you would then find ourselves in a situation whereby, like in BBI, this process of impeachment of the deputy president may end up being indicted as being a process that ended up being a government project, contrary to what was clearly spelled out by our laws. And my lord, if it turns out that all laws were broken, and virtually out of the constitutions, I was counting them yesterday, it looks that 30 provisions of our constitutions have been seriously violated in the manner that this process has been undertaken. Then we have a situations that Justice Brandeis had in mind when he